Good morning, good afternoon, or good evening, depending on where you are in the world. And welcome to Finnegan's second Asia Series webcast of 2019, Protecting Pharma Products from Advanced Development through Commercial Release. I'm Ming Yang, and I'll be your moderator today. It's my pleasure to welcome our presenters, Paul Browning and Adriana Berge. Adriana Berge is the leader of Finnegan's Patent Office practice. Her practice focuses on opinion work, client counseling, patent prosecution and management, and litigation in the chemical, pharmaceutical, and biotechnology arts. She has assisted clients in the early stages of development through due diligence and patent portfolio analysis. With the changing landscape under the America Invents Act, Adriana has counseled clients to prepare for the historic reforms and to develop long-term strategies moving forward under the new regime. Paul Browning focuses on patent litigation and appeals, primarily in the chemical and pharmaceutical areas, including Hatch-Waxman litigation. He has tried cases before judges in various U.S. district courts and has also handled arbitrations and mediations. Paul has led teams as first chair at trial, at Markman proceedings, and on appeal. In addition to his litigation practice, he advises clients on a variety of patent matters, including coordination of prosecution and U.S. and foreign litigation strategy, and related proceedings before the PTAB. Before I turn things over to our presenters, I invite everyone to participate by submitting questions. This is an interactive webinar. Just click on the red Q&A button at the lower center of the webcast interface and type your questions into the Q&A window. Then click Submit. The questions will be answered today during the question and answer section, which will take place at the conclusion of the presentation. You may enlarge the slide window at any time by clicking on the green Enlarge Window button at the top right side of the slide window. The slides will advance automatically throughout the event. If you are experiencing any technical difficulties, please click on the yellow Webcast Help Guide button in the lower center of the webcast interface. And now, I will turn it over to Paul and Adriana to begin our second Asia Series presentation, Protecting Pharma Products from Advanced Development through Commercial Release. Welcome, Paul and Adriana. The floor is yours.
Thank you, Ming. Hello, and welcome to the webinar today. We will be discussing some very exciting and interesting topics to help you protect your pharmaceutical products. First, we'll start off by taking a look at different ways to cover pharmaceutical products through drug development by examining different claiming strategies. Next, we'll discuss how to avoid public disclosures in the drug discovery process. Further, we'll examine Orange Book listing, how, what, and when. Additionally, we'll take a look at litigation considerations during patent portfolio prosecution and development. Finally, we'll take a look at the law of obviousness and what recent decisions are teaching us. So with that, let's go ahead and begin. And where better to begin, but really at the beginning of drug development to figure out how best to protect drug candidates for clinical evaluation. Look, drug discovery and development is a long and expensive process where failure is pretty much normal. Typically, drug development is in stages, and many drug candidates do not make it out of all of those stages. That is, drug development can be thought of in three different buckets. We've got drug discovery, preclinical testing, and clinical trials. And out of those buckets comes many drug candidates with a lot of potential. But how do you protect those candidates and that large investment? Well, you can do so with portfolio development and claiming. And so when you take a look at portfolio development, really you can think of it offensively and defensively. Offensively, what do you want to do? You want to build barriers to block those competitors. Maybe you want to file on related discoveries. Maybe you want to use various different USPTO procedures to block others from getting overly broad patents. Next up, when you look at it from a defense perspective, you want to make sure your product is valid and enforceable. So therefore, you want to ensure that you have some focused claims and you can ensure validity and enforceability. Now, as we think about building portfolios both offensively and defensively, what also do we need to understand to protect? That is, we need to understand where the interested drug candidate fits into the product pipeline, realizing its position most likely will change dramatically as it goes through that course of development. So here are some considerations on this slide to think about not only at the start of the life cycle, preclinical, but really you need to ask these questions as you go throughout development. For example, first and foremost, understand the invention and reasonable alternatives. What are you trying to get a patent on? What's your product ultimately going to look at? Where's that commercial value? Not only from if you're the innovator, but also from that competitor. You want to understand that competitive landscape. How is the product made and how is it used? And look, again, the name of the game here is evolving and pivoting, because most likely what it started out preclinical is going to change and evolve as it goes through that clinical process. And oftentimes this is overlooked, and that's the design around possibilities, such that, again, you're building a portfolio around a product or product line that contains various different shapes and sizes of barriers to entry. And finally, another consideration is Orange Book listability. And I know Paul's going to talk about some Orange Book listing issues, but that's also a consideration as you start to build your portfolio and you think about different claiming strategies. So with that understanding, let's take a look at that clinical process. And we start this clinical process in the preclinical stage. So here we see what's preclinical drug development? We've got drug discovery. It starts that process to determine safety, efficacy, what are the characteristics of that potential candidate. We then take a look at testing, animal testing, in vitro and in vivo. And then finally, it's that investigational new drug, that IND application that gets filed. And with the filing of that IND application, that clinical trial process can begin. And a typical preclinical trial phase includes several aspects, such as ones that we've listed here on the slide. And look, these are not the only aspects to consider when you're doing preclinical trial phases, but these are certainly things to consider. You've got the manufacturer of the drug. How are you going to formulate it? How are you going to dose it? Absorption, distribution, metabolism, excretion, those ADME studies, toxicology, got to think from a manufacturing perspective, GMPs. And by examining those aspects, it really informs us of opportunities how to protect that interested drug candidate. That is, it informs us of those different ways to seek protection. For example, and probably foremost, is that discovery and identification and characterization of that lead compound. And that lead compound is that active pharmaceutical ingredient that is the beginning of development. And it's that opportunity here for protection. Look at the activity, the physical and chemical properties, chirality, enantiomers, crystal structure, the form of the API. And that's just the lead compound. Next up, we have pharmacokinetics. Once the drug is administered, how the body treats that drug throughout its absorption, distribution, metabolism, and elimination. Those are all ripe areas for claim protection in order to, again, offensively and defensively protect that drug candidate. The same holds true for exploring the drug's safety and efficacy, the toxicology, and how you supply that drug and how you manufacture it, how it's prepared, the different forms, the salt forms, enantiomers, polymorphs, formulations. Those are all areas ripe to consider in determining how to protect those interested drug candidates. The problem, however, is that you just can't file on all of those different aspects because likely you just don't know all of that information. So what do? You really try to identify those opportunities as they arise, and you have to maintain an IP awareness within the company to avoid inadvertent disclosures. And you have to be aware of what's already been disclosed, as it may present hurdles later in development. And we'll go ahead and talk about that in the second section where we talk about public disclosures and commercial use. Next, from a clinical perspective, we have all these different phases that the drug candidate goes through. Again, those phases, they have different objectives, but they also present opportunities to think about protection. When you look at a phase 1 clinical trial, what are you doing there? You're trying to characterize side effects, understand that absorption, distribution, metabolism, excretion profile, what's a safe dose range, the structure-activity relationship. You need to gather all of that PK information then to design valid phase 2 studies. When you look at phase 2, what are you doing there? Those are to evaluate effectiveness. Those typically are well-controlled, closely monitored, and conducted in a relatively small patient population. And then you look at phase 3, you're doing a larger study in different populations. And again, you're gathering that additional information. So when you think about it, with that backdrop of all those different phases, there are some considerations for additional protection based on those results. Again, when you think of it big picture, preclinical, really you're thinking, okay, I want to protect early on that compound and that composition of matter. But when you get into those clinical trial considerations, kind of the world opens up to take a look at different opportunities for protecting that product or that product line. How do you use that product? Maybe this is an old drug that's being repurposed. Think about that. What type of formulation? It may be in phase 1 you have a orally dosed drug, but by the time we get to phase 3, maybe it's switched to something that melts in your mouth. Again, the specific form of the drug, the dose regimen, all clear opportunities to get further protection. And the last 3 that we have on this slide, the label language, unexpected results, and patient subpopulations are hugely important. That label language would be great to have in a claim. And again, you may be having to pivot as you go through the process. So you want to be able to create an application that provides for these different alternatives and options and opportunities, but at the same time realizing that there's a balance that needs to be struck here, that you can't disclose too much because it may later come back that you can't do a selection invention later on, that it turns out, oh, when I treat this particular disease, we get unexpected results. So it's a lot of balancing that occurs. And then you also don't want to forget about post-marketing studies, phase 4 studies. There's another opportunity to determine whether there's subject matter available for protection. And while it may seem that I'm repeating myself here a little bit, it really further evidences that evolution that the clinical process goes through with different drug candidates and the extent of information that is gathered, that things are constantly changing, and that from a patent perspective, one needs to be able to pivot and again have different options available to cover what is ultimately that final product. Because when you get to phase 4, you've already got that final product out there, but you may be looking at different things at this point. Maybe there's a subpopulation. Maybe you had to come up with a warning or a precaution. Again, that label language is important. Maybe there's additional methods of use and combination drugs. Those are all ripe considerations for additional protection, such as, look from a second-generation perspective: formulation, dosages, routes of administration, methods of treatment, pediatric or geriatric use. Again, a combination with a second active agent. And I think the other thing to consider, and while it doesn't necessarily fit under this post-marketing heading, maybe there is an opportunity to get protection outside of the patent world. Maybe it's the design aspect. Is there an ornamental design of the pill, of the tablet, a color, maybe the bottle? Maybe there's design protection that you should be seeking as well. And what about trade secret protection? Maybe there's aspects of the process that can't be designed around, or that maybe there's aspects of the process that are better suited for trade secret protection. Maybe they're hard to determine, hard to, retrofit later on. And again, another consideration, which is really outside, trade secret and design patent and patents in general, is, copyright for your prescribing information. Maybe there's certain aspects that should be copyrighted. Now, on this last slide, we have some additional thoughts. That is, above all else, I think one of the main things as you're doing preclinical development and you're coming up with different claims is to remember that, first and foremost, your claims need to be novel and new. And we'll soon talk about some of that. But here, I think you need to consider the timing of your filings, what to include. For example, if you filed too early, when you're filing early, you need to ensure you have enough information to support that application. And at that particular stage, that it is patentable, it's patent ready, because when and if it publishes, it will be art that you will have to need to overcome. So think about 101, 112, written description, enablement, etc. The same can be said if you file broad disclosures. Again, you may have prior art problems, and it may force you not to go after a selection invention. And I've seen this multiple times and have dealt with it where there's filings too early and they're too broad because they really present prosecution hurdles later on when we're going after species, when we're going after a selection, a particular use in a certain patient population, because all of that art will get cited against us. And it leads us not only to seek very narrow coverage, but during prosecution, we have to not only make arguments of record, but then we have to go with some declarations, do interviews, and it creates a lot of prosecution history estoppel. And it also opens us up to design arounds. So really, when you take a look at, claiming strategies and how you go through this clinical development from preclinical to clinical trials to post-marketing, you have to take a look at all that ripe data to see where the best protection that you can get, and not just a protection, it's varied protection. Strategic planning is really the best. You can't say enough about planning and thinking through your different options. And at the end of the day, you want to have options to assert against a potential infringer. Options, options, options. It's not just a particular Orange Book listed patent, but maybe there's stuff that you also should seek protection that may not be covered by Orange Book listing. There are other ways to protect it, whether those are manufacturing processes, whether that's intermediates, etc. So these are all things that you should consider as you go through that clinical process. Now, next up, we have, we'll take a look at how public disclosures can sync your patent coverage. And look, it's easy to say, don't make any public disclosures. Don't create an on-sale bar, meaning, don't make a commercial sale before you've filed a patent application. But sometimes, it's just not easy to practice that advice. And as we know, Section 102 precludes a person from obtaining a patent on an invention that was in public use, on sale, or otherwise available to the public after the filing date of the claimed invention. So how do these disclosures happen? Well, a lot of times it arises when we go through that clinical testing. Clinical testing occurs in a public setting. there's publications on the clinical trials, there's clinical trial patient agreements, there's investigator agreements, and then maybe there's potential agreements to sell. And so when there is a public use or an on-sale bar issue, it may actually not disclose the entire claimed invention, but enough that then we may get taken out of, and it's not a 102 issue anymore because all of those elements of the claimed invention weren't present. But what it turns out is we create a strong obviousness argument for us. And I know Paul's going to go over some recent obviousness case law, but you can't just think about 102 because you may be able to get out of that 102 space, but then you're right back into a 103 space, an obviousness space that really creates a strong presumption of obviousness. Now, instead of launching into a bunch of slides about the case law, really what I thought would be more informative was to discuss how these issues arise, considerations when they do arise, and things to think about. For example, a public use disclosure, you need to keep in mind that these are highly fact-specific, and you need to investigate to really understand if the public use disclosed all of those elements of the claimed invention. There may be an opportunity to argue experimental use, the experimental use exception, and we'll go through that in a little bit. You really want to figure out what activity really occurred in the public. Was there really public access to that use? And were there any confidentiality obligations imposed on those members of the public? So how does this typically manifest itself? Well, it's usually from the patentee's clinical trial publications. Maybe it's access and disclosure to study investigators, those physicians. Maybe it's the study participants themselves, the patients. Were all of those claimed features placed in the public's possession? Is there confidentiality agreement in place? And so really the question boils down to, could the public readily discern those claimed features? So let's look at some of the types of typical documents that come from conducting clinical trials in the U.S. First up, we have the drug is released to investigators and participants. Typically, the drug release also includes clinical instructions on how to use and administer the drug. There's also usually a disclosure on the clinicaltrials.gov website describing the clinical trial. There may also be an abstract of the clinical trial somewhere, maybe an academic publication or a poster presentation detailing the clinical trial. So you really need to stay vigilant and monitor what is being disclosed. It also, another disclosure opportunity is on your own website. The investigator's product labels, marketing information. And so we get a lot of questions. Well, does all this amount to a public disclosure? And here, look, again, this is highly fact-specific, but in most instances, those disclosures don't amount to a public use because the invention is not really fully disclosed. But again, you have to be vigilant that full disclosures of the invention are not made. For example, study drug labeled, use the internal code name on that label. If you're putting dosages there, maybe do a dose range, not provide the exact dose. Again, looking at patient agreements in clinical trials, and most likely you're not going to be able to seek a confidentiality agreement with patients because that may be inappropriate, as patients need to discuss issues with their doctors, the caregivers, others that are involved in their care. But you do have patient consent forms that talk about the risks, the dosing schedule, directions for administration, but you can also argue that, there is no public use because the use was confidential, controlled by the patentee. Oftentimes, patentees seek the return of any unused study drug, and likely not all aspects of that clinical trial is disclosed to the patient. You don't want that clinical trial to be biased in any way, and maybe the patient's even on placebo. So again, be vigilant. Look at those patient agreements, particularly that consent form, to see if you can make an argument that, look, you still maintain control. There was not that full disclosure of the invention. Next up comes the clinical trial investigators. And now this is where it gets interesting, folks, because these people are highly skilled in the art, which means that this person has the ability to understand and disclose the invention to others. But here, best practices are you really need to secure a confidentiality agreement with each investigator. And this allows you to argue no public use because you got the confidentiality agreement and the patentee. What does the patentee maintain? They maintain control. But again, be vigilant because it pays off having that confidentiality agreement because you also want that confidentiality agreement to cover results from the clinical investigation. You want the company to be able to file on any study results, any data before there's any public disclosure. The same holds true for potentially new inventions where there's unexpected or synergistic type of results. So switching gears slightly from public use to more of an on-sale perspective, here there's really, between public use and on-sale bar, there's really no bright line. So there may not be, you may have public use with an on-sale, but generally speaking, when you have clinical trials, there's usually no offer for sale. There's no sale because, there's no exchange of money between the investigator or participant. Usually the study drug is free. I think what you need to consider when you look at the on-sale bar is an offer to sell the study drug is sufficient to raise the on-sale bar even if it's never consummated. So if you're in clinical trials that resulted in some unexpected benefits or improvements, but you made an offer for sale, you may be barred from filing an application to that improvement or that benefit because of that offer for sale. And so agreements with partners, distributors, or customers may trigger that on-sale bar, but it's, again, highly specific. I have on the slide here, can a patentee hire a drug manufacturer to make the drug product without triggering the on-sale bar? Well, that was in Medicines versus Hospira. And here, again, highly fact-specific. The Federal Circuit characterized the transaction as just manufacturing services, not a commercial sale. There was no authorization of release of the drug, and they retained control over the title of those goods. So again, highly fact-specific. Next up, we just wanted to touch slightly on experimental use. Experimental use is a touchy subject these days, and there's some doubt surrounding the doctrine's viability in view of some court decisions in AIA, but this is really a judge-made doctrine that provides protection for experimental uses of an invention determined courts have established, what to look at, different factors to look at for experimental use. And some of those factors are necessity for public testing, the amount of control the inventor had over the experiments, the lengths of testing required, whether there was payment made. Again, payment made suggests commercial sale. Any secret obligations? Did we keep records of the experiments? Who conducted the experiments? The degree of commercialization and during testing. If the invention needs evaluation under test, do you have to evaluate under testing conditions? So all of these different factors really come up with a totality of circumstances. Again, highly fact-specific. But experimental use can negate public use or the on-sale bar. But again, the primary purpose really needs to be for experimentation. These next two slides really just deal with the grace periods under 102 or the not-so-grace periods. The grace period is really an exception to a loss of novelty because of an action such as a disclosure that occurred prior to the patent filing. So under AIA, the grace period is defined as basically there's a one-year grace period for the inventor's own disclosure or disclosure of the inventor's work by another, and it also covers disclosure by a third party is not prior art if the inventor disclosed first which was followed by a patent application filing within that year time period from the initial disclosure. But these grace periods should be used as last resorts because, in certain countries, you don't necessarily have that grace period, so you may be stopped. They may have absolute novelty, which you'll be stopped from filing that application. That last slide really just goes through those exceptions for the grace period. And I just wanted to end here with some of these we've already talked about, but ways to minimize that risk of a public disclosure or an on-sale bar. Some of these bear repeating. Really, ideally, you just don't want to do it. You don't want to try to make a commercial sale before you patent the invention, before you have a filing date. If you can fall within one of the grace periods, that's great. But again, you want to control that dissemination of information. Try to develop internal systems, limit publicity, and really the last bullet point here is most important, which is internally communicate with all those different team members or potentially departments to monitor those disclosures throughout the clinical trial process to ensure that those disclosures, whether it's on clinicaltrials.gov, whether it's a poster presentation, they don't necessarily link all of those parts of the invention together because you will ultimately have to deal with that either in prosecution or later on in litigation. And ideally, you would rather just deal with it in prosecution because you have that opportunity to amend your claims during that process. So next up, I'm going to hand it over to Paul to go over the remaining sections of the presentation with Orange Book listing. Paul?
Thank you very much, Adriana. I listened with great interest to the first part of this presentation, and I think Adriana gave us lots of things to think about and certainly lots of things to watch out for. I also see from our attendee list that there are several people on there that we know very well, and I appreciate you joining us for the webinar today. So the next topic is Orange Book listing. We'll go through this quickly. This isn't a talk on Orange Book listing, but it's important to frame the rest of the discussion. And of course, here we're focusing on small molecules, so hence the Orange Book. But in the future, biologics are becoming more and more important. And many of the things I'll talk about, and certainly that Adriana has talked about, apply equally to biologics. But the Orange Book, as I'm sure probably everybody on this webinar knows, is a very important resource or document that the FDA maintains, and the NDA holder must submit to the Orange Book for listing patents on the NDA drug substance, the product, and or its use for which an infringement claim could reasonably be asserted. And so it's technically a requirement, though I don't know if it's ever actually been enforced, but it's certainly in your interest as the innovative drug company who has an NDA to submit to the Orange Book any patents they possibly can that might cover the use of the drug substance or the approved methods of use. Now, it certainly, the Orange Book does serve a role in giving public notice of the patents, but what I'd like to focus on is the benefits to the NDA holder and patentee. And that is, there are really some very valuable rights that you potentially gain by listing patents in the Orange Book. Listing patents enables the patent holder to file suit under the Hatch-Waxman Act and claim for infringement under 271E2, and that will prevent, under most circumstances, a generic company from launching its product until the patent infringement issues can be litigated. So that's a very valuable right. And the other valuable right is there are certainly certain remedies that are associated with Hatch-Waxman litigation, most importantly the resetting of the ANDA approval date, which essentially acts as a acts as an injunction stopping infringing generic sales. So those are very important rights that a patent holder has and can acquire through Orange Book listing, and therefore the Orange Book is of prime importance for NDA holders. And so certain types of patents can be listed in the Orange Book and can be tied to those important benefits, and some can't. But certainly the drug substance or the drug product, to the extent it's the actual approved drug substance or product, can be listed in the Orange Book. There are some complex rules when it gets to salts or esters, and I would encourage you to look at those if you have that type of situation. But in general, if you have a patent directed to the active ingredient of your drug product, it can be listed in the Orange Book. Polymorphs are another interesting area. They can be very valuable patents. The actual polymorph that is the approved drug product, that a patent claim to that polymorph can certainly be listed. You can also list patents to other claimed polymorphs, but the requirements are a bit stringent. You essentially need to show bioequivalence of a drug product containing that polymorph, and so in practice it can be very difficult to list those patents. Method of use patents can be listed to the extent that method of use corresponds with an approved indication in the product label. There are other patents that are not Orange Book listable, but are really important and are patents you want to think about obtaining with respect to your drug product, to the extent you have the research that would support that. Processes of manufacturing or making the drug product can be very important. And so what I should say is these other patents that aren't Orange Book listable could still be asserted in the Hatch-Waxman litigation. Therefore, they can add value in protecting your product. So metabolites can also be sometimes valuable patents, intermediates, packaging, and the product by process where the product is not novel. If the product itself is novel, that's listable in the Orange Book. But the product is not novel, then maybe you have a product by process that's not listable in the Orange Book, but can be asserted along with other patents in the Hatch-Waxman litigation. And you may not have the same benefits as an Orange Book listable patent, but they can still be asserted with a claim of infringement. These are other claims to consider. For Orange Book listing, newly isolated or synthesized chemical compound, a new chemical derivative, analog, prodrug, or isolated metabolite. Again, all these compounds need to be approved. It needs to be an approved drug product, but they're things you can think about during product development as ways to claim or things that can be claimed that can ultimately be listed in the Orange Book. A new salt or a polymorph crystal form, they can be extraordinarily valuable because they can have different properties that can lend to better manufacturing or better properties when administered to a human, and therefore they can be very valuable. New formulation within active ingredients, a new combination of known active ingredients, a new disease indication for a known drug. If that new disease indication is approved and in the product labeling, that can be a listable patent claim or listable patent. A new patient population, a new route of administration, a new dosage amount. Those can be extraordinarily valuable patents and can be often be very surprising discoveries. A new dosage regimen, again, can be very valuable patents. Or the device or packaging, typically that might not be listed, but if it's part of the approved product, then it could very well be a listable patent. So let's jump forward and talk more about portfolio development from a litigation perspective. Adriana talked in the first part of the webinar about claiming strategies and things to consider throughout the development of a drug product. I want to focus on probably some of the same points, but from a litigation perspective and things to think about when you're looking forward to protecting your approved product in a patent infringement litigation. And so the first point is maybe the most important point, and I'll expand on it a little bit. You want to consider who will infringe your patent claims, right? Who are you going to sue? Who can you sue? And also, I don't have it listed here, but equally important, how are you going to prove that that party is infringing your patent claim? Do you have a patent claim that you can prove someone has infringed? You might think that sounds very straightforward, but in practice it can be a little bit tricky because what happens is in fighting to get patent claims allowed from the patent office, you've added lots of limitations. And some of those limitations might end out to be very difficult to prove someone else is practicing. And if that's the case, you want to think about, do I have a continuation application? Is there some way I can clean this up to get a more simple claim for which I can show infringement? You also want to think about who is actually infringing that claim, as I mentioned earlier. That can be important. You don't want to sue a patient. That's not a very good business model. You'd much rather sue a company. You can sue a doctor. It's not the best, but you'd much rather sue a company if you can. You want to think about, is the claim directed to a single party? If it's a method of use, sometimes complex methods of treatment can involve actions by doctors and patients. Now, you'd never sue doctors or patients. You'd sue the company under a claim of induced infringement. But still, if you have combined actions by multiple parties, you may or may not be able to successfully assert that patent claim. And I would direct you to the ACMI line of cases. But you need to show, generally speaking, that the actions can be attributed to a single entity. And if you can do that, you can assert a claim where more than one party is practicing it. But those can be very difficult claims to enforce, and ideally, you want to have a claim that is simple and directed to a single infringer. And so these are things you think through before you file suit to determine whether you could develop better claims and maybe solve some of the problems you may have with your claim set. I've also thrown in here include claims directed to downstream products. I'm not sure that's always applicable in the pharma context, but it's something to think about. Here the case is the Monsanto case where there were claims to the Roundup Ready plants and also the seeds of those plants. And so the seeds were the downstream product, and the patent was enforced against use of those seeds. Let's think about prosecution activities that are taking place during litigation. Now, I would typically advise, and I do advise clients that to the extent you have something very valuable, a new drug or what have you, and you're going to get into litigation, to the extent you have a patent application pending, you want to keep a continuation alive. And the reason is that gives you some flexibility to later draft better claims as time moves forward. Now, there's some downsides that come with that approach, and that's what the focus is here on this slide. First of all, to the extent you get into litigation and you have an active patent portfolio, will you need to make new disclosures to the patent office in ongoing prosecution? Is that going to be expensive? Is that going to bog down prosecution? Is that going to lead to new rejections that you wouldn't already have? Will the office action make rejections that will impact your litigation positions? For example, what if you submit to the patent office prior art that's being considered in your litigation and new patent claims are rejected over that prior art? Is that a bad fact? May or may not be, but it could be a bad fact for your litigation. Conversely, if you submit prior art to the patent office while litigation is going on and the claims are allowed, maybe that's a good fact that you've created and can help you in litigation. You just don't know, and these are risks or possible possibilities to help your case that happen. And importantly, can you use what you learn as time goes on to craft better claims? Now, if there's litigation, there's typically a protective order that will prevent you from using information in the litigation to amend claims in prosecution. However, lots of information is released into the public domain, and you could consider using that public information to craft better patent claims to better protect your product and your rights going forward. Ongoing coordination can be critical, and I think this hits on a lot of the issues that Adriana was talking about and ways of making sure that you're best protecting your company's position. So you want to know what actions are your regulatory personnel taking and what positions are they taking before the agency. That can be really important. Statements that your regulatory individuals, personnel, make to, for example, the FDA, those statements could be used against you in litigation. So you want to make sure they're not saying something that's inconsistent. For example, maybe they say something that's completely inconsistent with how you understand the claimed invention was developed. Those statements can be made innocently by mistake, but they can have negative consequences for you in litigation. You also want to pay attention to what regulatory is doing with respect to labeling. If you have a claim of induced patent infringement that is typically based on information in the product label, the ways the label language may change going forward could either help you or hurt you with those claims. You also want to look to what's in the pipeline, what's being developed by your commercial people, your new product development group. What is the new drug product and how is it being protected? Are you taking positions that may be inconsistent with positions you may later want to take to protect that product? So in some sense, this slide is a bit of bad news for those of you who work in-house, in that you have to know everything that's going on at your company in order to do your job as well as you can. And unfortunately, on the next slide, the news gets worse, that you not only have to know everything inside your company, you have to know everything outside of your company in order to best protect your products and to ensure you have the best intellectual property. You'll want to identify and track other players in your space. To the extent you're working on something valuable, you can bet there's a good chance other people may be interested in doing work in that area as well. So you want to look to who is the competition, and are they trying to solve the same problems you are, and what IP are they pursuing to the extent there's public disclosures. You also want to know what's been done in the past, obviously, identify the relevant prior art, and make sure that you're avoiding it. You also want to look at the evolving case law. For example, case law and written description keeps changing. I'm going to discuss some obviousness decisions in just a moment, and you need to keep track of that. And have those changes to the law impacted the value of your portfolio? You need to reassess periodically to think where you are. I work a lot with Tom Irving, and I think what Tom would say to you all about these last two slides is the next time you're going to your boss and you're looking for a raise, show them these two slides that I've just discussed and show them how difficult your job is and all the things you need to keep track of to do the best job maintaining your company's patent portfolio. And maybe that will enhance your chances of getting a raise. So let's go to the last topic. We're running short on time, but I've got just enough time to go through some obviousness decisions. Now, when Adriana and I were first thinking about putting together this presentation, we thought, well, there'll probably be some really difficult obviousness decisions that will be bad news for the pharma community, and we should talk about them in this webinar. But in the last few months, actually, there have been some pretty good decisions on obviousness. So I'm happy to report that I'm just going to talk about cases that are good news for those of us who have patents protecting your company's brand name products, and they really came out in the right direction on obviousness. And I'm going to start with inherent obviousness, which is a really tricky doctrine. In some sense, it really doesn't make a lot of sense, because inherency, as we all know, is something that's in the prior art but it's not disclosed. And obviousness is a doctrine based on what is known. What is obvious based on what is known and clearly disclosed in the prior art. And therefore, the idea of inherent obviousness doesn't make sense. Well, it's a very narrow doctrine, and the way it's been applied is if you're making an obviousness argument or a determination, and you're combining two or more prior art references, one of the limitations that you need to show to establish obviousness could be inherent and still establish an obviousness determination. But that only happens under very narrow circumstances, which I'll discuss. So here's the case. It's Endo Pharmaceuticals versus Custopharm. And Endo had two patents related to a testosterone replacement. Okay, and so the claims were directed to a method of administering a 750 milligram dose of this testosterone compound and undecanoate in a vehicle containing 40 to 60 by weight castor oil and benzoyl benzoate. So this is the important part, the vehicle. And if we go forward, so there were three prior art references that were asserted, okay, and they involved an administration of 1,000 milligrams, so very close to the claimed dose of TU in castor oil at the claimed dosing intervals. Okay, the references, as I say here, never claimed. They don't disclose the 40 to 60 ratio of castor oil to benzoate. They say nothing about it. Okay? However, there was a later reference, SOD, that established that these earlier prior art references in fact used this vehicle of 40 to 60 ratio of castor oil to benzoate. And so the defendant said, hey, that's inherently there, and this is a case of inherent obviousness. The district court disagreed, and the Federal Circuit affirmed. The Federal Circuit found here that just because it was a fact that the prior art references used but did not disclose this vehicle, that was not sufficient to show inherency as used in an obviousness argument. And the Federal Circuit relied on Parr versus TWI Pharmaceuticals to reiterate that a challenger must prove that the limitation at issue necessarily must be present or is the natural result of the combination of elements explicitly disclosed in the prior art. Here, the defendant had not shown that the prior art substances needed to have this vehicle to exhibit the properties shown in that prior art. And those properties were certain PK profiles. And the defendant had not shown that other vehicles could achieve that same result. If that defendant had proven that this was the only composition that could yield the results shown in the prior art, then he might have had a case, but the defendant was not able to do so here. So the take-home here is that, fortunately for patentees, inherency and obviousness is going to be more narrowly applied by the Federal Circuit going forward, and that's good news, especially for such an unpredictable and confusing doctrine. The lead compound analysis, this is a really interesting case, and again is good news for those of us who try to protect patent rights and try to fend off obviousness challenges. So here, this is actually an appeal from a PTAB decision. The patent at issue discloses methods of using purified glycosamides for treating CNS disorders. So there are 3 prior art references at issue, but here's the key issue. So there was a very, very close compound in the prior art. It was chemically almost the same as the claimed compound. But it differed in that the difference was between a CH group and an NH group. Now, the defendant said, well, there's this principle of isosteres and bioisosterism, which is sort of a classical principle of organic chemistry, that certain certain groups will behave similarly. And they had pointed to a textbook saying that an NH linkage was very similar to a CH2 linkage and said, hey, this shows that the compound is obvious over this very similar compound in the prior art. Well, and here on this next slide, I show these 2 compounds. And you can see if you focus on the NHOCH3 group dangling up on the left side and the CH2OCH3 group dangling down on the right-hand side, that's the difference. It's very close. But the actual facts of the case trumped this sort of classical general principle of bioisosterism. And here, the prior art suggested that this type of chemical change would give reduced functionality and would create a significant conformational change that would likely change the biological properties of the drug in the body. And therefore, here, the actual facts of the case trumped sort of this general principle. And those of us who fight these fights before the court see these kinds of arguments all the time. Attempts to raise sort of standard or broad principles of organic chemistry to argue that a compound is obvious. This is a great case for pushing back on those arguments because here the actual facts were more important than general principles of organic chemistry. Now I'm running short of time. I'm just going to jump through this last case very quickly. Again, it's a great story for those of us who protect patents because here the question is, what are the value of FDA communications to the NDA applicant in an obviousness determination? And again, those of you who litigate these cases know that these types of arguments come up all the time. the defendants trying to show a patent is obvious will try to point to FDA communications and say those communications during drug development render the claimed invention obvious. And here, that type of argument was rejected. Here, the claimed invention was to a very pure form of oxymorphone, and the FDA communication at issue was a request that the NDA applicant achieve a certain level of purity. The FDA obviously didn't tell the applicant how to do that, just told them to do that. And that wasn't deemed to be enough here to render the claimed invention obvious. Now, there was a dissent from our favorite Federal Circuit Judge, Judge Stoll, who is a former partner of Adriana and myself. But notwithstanding her dissent, I think this case is a really helpful case for those of us who are trying to push back on arguments that FDA communications somehow render a claimed invention obvious. And those of us who work in this general area and are familiar with these interactions with the FDA understand that the FDA doesn't invent things. They make requests of applicants, and applicants have to determine the difficult scientific questions on their own. So I think we're close. We are actually very close to our end of time, and I'm going to shift things back to Ming to do our question and answer section.
Thank you, Paul. And before we begin the question and answer portion of our event, please take a moment to complete our brief evaluation survey. As we strive to provide programs of value and continually improve, we would appreciate your input, which will guide us in planning future programs. It's now time to address questions from the audience. We love questions, and we encourage you to submit your questions. To participate in the Q&A, just click on the Q&A button and type your question into the Q&A window, and then click Submit. So Adriana and Paul, I'm turning the floor back to you. Looks like we have some very exciting questions from the audience.
Thanks, Ming. This is Paul. If I could jump in quickly, I see a question here that I think is really perfect for Adriana, and so thank you all for paying attention. The question is, what types of patents should protect an active pharmaceutical ingredient?
That's a great question, Paul, and I think it's a common question that we get asked often. And, unfortunately, the answer to that is it really depends. As we talked about earlier in the presentation, there's ample opportunities for protection, whether it's the lead compound, the active ingredient, whether it's the formulation, maybe there's some PK parameters that you should get protection from. But I think the key to that question is really seeking a diverse coverage of that drug product, such that, again, as I reiterated earlier, is that, you have different options to go into litigation. You not only have your Orange Book listed patents that cover, as Paul said, the compound itself and those different methods of use, but you also have other options that may not be Orange Book listable, but are viable options during litigation and that you should consider. So really, I think the answer is it's a varied approach, and it depends on your active ingredient, but you really just need to take a look at those broad spectrum of different types of claims that you can pursue and those different types of applications to pursue, and really try to come up with a strategic and balanced plan going forward. And Paul, it looks like we have a question here that I think is apt for you. And the question is, do you have any practical advice on how to ensure coordination between the legal department, regulatory, and drug development groups? Paul?
Thanks, Adriana. That's a really great question, and I'm encouraged that it's being asked, because it's a very important question to ask and to think about. And what I would say is, I think what's most valuable is, and it does take time and it takes some effort, but it's to get people together, get them preferably together in a room and have a discussion. You obviously can't do that every week, but maybe you pick every quarter or every half year a time to really get different people with different responsibilities in these different areas together to talk and share information. Sharing information is so critically important, especially when you have a very valuable product you're developing. You want to make sure you're doing the best to protect it, and to the extent you are working on the patents, you're going to want to know what regulatory is thinking and what drug development is thinking, and they're going to want to hear your advice. So I strongly encourage you to find time to meet up with your colleagues and make sure there's a good sharing of ideas. And with that, I think we're right at the end of our presentation. I want to thank everybody again for joining us tonight. This has been really a pleasure for us, and thank you for listening.
And again, thank you for attending today's Asia Series webcast, Protecting Pharma Products from Advanced Development to Commercial Release. This presentation will be available on demand in the next week. Please look for an email from us within the access link. This concludes today's Finnegan webcast. Thank you for participating, and thank you, Paul and Adriana.